This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about crime. And this story is called Go to Jail, Do Not Pass Go, Stay in Jail. Why an insurance agent defrauded his clients by keeping the premium for his own benefit. In United States of America versus John M. Thomas, the 11th Circuit Court of Appeals on February 20, 2024, dealt with an appeal from Thomas seeking to reduce the 168-month sentence he received for 16 counts of wire fraud, 4 counts of money laundering, and 4 counts of money laundering to conceal proceeds of an unlawful activity. Between April 22, 2013 and February 16, 2021, Thomas defrauded 69 of his clients at Thomas Insurance LLC in Pensacola, Florida, through premium diversion. Thomas collected insurance premiums from his clients and falsely represented to them that he purchased insurance policies. Thomas provided his victims with fraudulent insurance documents indicating the fake policies were in effect. He also falsely represented to one victim that he had obtained an annuity by providing a fraudulent contract and portfolio summary. After Hurricane Sally hit the Gulf Coast in 2020, several of Thomas's victims learned they were uninsured as they sought to file claims for hurricane damage to their property. Through premium diversion, Thomas received payments of at least $4.8 million from his victims, and his fraud cost at least an additional $2.2 million in unpaid claims caused by hurricane, fire, and liability losses. When one victim attempted to submit a claim, Thomas directed the victim to send photos and damage estimates to a fake Colorado company he created called JSSK Risk Advisors LLC. Thomas pretended to be an insurance adjuster named Scott Powery at JSSK Advisors to deny the victim's claim, who really had no insurance. Thomas was indicted on 16 counts of wire fraud. The violations involved the following 4 transactions: a $50,000 transfer from his bank account to his family trust bank account, then transferred to purchase a Lexus; a $278,730.14 transferred from his bank account to his family trust bank account, then transferred to purchase a condominium on Pensacola Beach, Florida; a $30,469.80 check from his bank account to exchange for a 20-ounce gold coins; and finally, $97,557.19 transfer from his bank account to an E-Trade brokerage account. Thomas pled guilty to all 24 counts after the magistrate judge conducted a colloquy with Thomas to ensure that he was pleading guilty knowingly and voluntarily. At his sentencing hearing, Thomas's counsel objected to the sophisticated means enhancement, among other things, because counsel described Thomas's fraud as an incredibly simple crime, and that Thomas's ability to go undetected for almost 8 years stemmed from Thomas's special skill and the vulnerability of his victims, not sophistication. The court overruled all of Thomas's objections, including for sophisticated means. The 11th Circuit noted that evidence that a defendant converted funds into a form that is more difficult to trace, easier to hide, or less suspicious can support a violation of Section 1956. Thomas has not shown that the error impacted his substantial rights. Even if he could show that he would not have pled guilty, changing the outcome of his convictions on counts 21, 22, and 24 would not impact the enhancement for violating Section 1956, which only requires one conviction under that statute. An offense that has involved sophisticated means and that the defendant intentionally engaged in or caused the conduct constituting sophisticated means should always result in a 2-level increase for the sentence. Regardless of its elements, the scheme itself may be designed in a sophisticated way that makes it unlikely to be detected, allowing it to continue for an extended period and to impose larger losses. Even schemes with a sole participant can employ sophisticated means. The 11th Circuit concluded that the district court did not clearly err in applying the sophisticated means enhancement. Thomas's fraudulent scheme must be considered in its totality, and Thomas made them in a way that created a sophisticated scheme. Thomas created fraudulent insurance documents and fabricated an annuity portfolio. In addition, Thomas made up an email address for his alias Scott Powery and the fake JSSK risk advisors to deny one of his victims' insurance claims for a policy that never existed. On his own, Thomas managed to conceal his fraud for over 7 years and caused millions of dollars in losses to his customers. In light of the 11th Circuit precedent and Thomas's actions, the district court did not clearly err in applying the 2-level sophisticated means enhancement. In my opinion, Thomas, as an insurance agent, decided he was better at being an insurance company than an insurance company. He took in premiums from his friends and neighbors, never purchased the insurance they needed, denied their claims, and pocketed millions of dollars. When finally caught after a hurricane struck and his clients had no insurance, he pleaded guilty only to try to reduce his sentence in an amazing type of chutzpah by claiming his 7 years of stealing was not sophisticated. Thomas will serve his time in the Gray Bar Hotel, a nice federal prison. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in obtaining more detail about insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.